Good afternoon, everybody, and welcome to our 23rd webinar. Holmquist and Gardner, attorneys at law, started this webinar at the beginning of the COVID outbreak, and here we are, still going strong. And this one's one of our more well-attended ones, so demonstrating the strength of this. Thank you for attending. We are 8 attorneys practicing in business and real estate. We have a transactions team and a litigation team, and all of these webinars that we do are available on the YouTube. Crazy as it sounds, we have a YouTube channel. And so if you missed some of this or you think someone would find this interesting, feel free to forward the link that you'll be emailed after this presentation. As always, we remind you that this is a presentation for informational purposes only. If you need actual legal advice, you should retain an attorney. Of course, attorneys at Holmquist and Gardner are ready to help, but just any attorney on these matters would be great that has a focus in this. Now, today we're extremely excited to be talking about estate planning for business and real property owners. And part of the excitement is that we are really opening this up as a new practice area for our firm. For years now, we have been telling our clients that we do not practice specifically with regard to taxable estates. And now that we found a great new team member in Grayson Chester, we are offering these services. And Grayson's with us today in his 5th year of practice. Before this firm, he was at the Revocable law firm, practicing primarily in taxable estates and exclusively in estate planning. So today, as always, go ahead and ask questions in the chat as you see fit. We'll try to get to them. We'll try to keep this short and sweet. It is an overview, not intended for in-depth CLE purposes or something like that. Of course, I know Grayson could talk for hours about any one of these topics. We're going to go over tax planning. We're going to go over planning for life and planning for death. We're going to go over estate planning and administration considerations, estate administration. And finally, we're going to talk about updating your estate plan to the extent you already have one. Again, this is an overview, but do ask some questions and we'll try to address questions at the end if we don't get to them during the presentation. With that, Grayson Chester, take it away. Thank you.
Thank you very much, Imants, for that lovely introduction. Very happy to be here today, not just in front of such a lovely audience and here teaching this material in front of Imants too. I'm also happy, I think, more broadly to be here at this firm. As Imants mentioned, I have been doing estate planning for the last about 5 years or so, and I'm very excited to begin helping Holmquist Gardner, my new home here, with their estate planning needs. I've been friends actually with Hamilton Gardner for a couple of years now. And so they've been working, I think, a little bit to get the thought in our heads that I might be coming. And so lo and behold, now we are actually able to do more advanced estate planning. We're now able to handle taxable estates. And so with that in mind, I'd actually like to start this segment, this seminar, dealing with, as Benjamin Franklin said, death and taxes, the 2 certainties in life. And we're going to start here with taxes. So let's go to the first slide. Right. So I want to talk very briefly about why it is that I'm even leading with this material. As you may have seen in the seminar title, we're tailoring this a little bit more focused, not about estate planning broadly, although I can certainly do a lot of that. I want to talk about estate planning for business owners and estate planning for real property owners. And knowing a little bit about what we do here in Western Washington, I know, both because of my practice and also because of this type of clientele, that tax issues are very often either first and foremost in your mind, or they should be. One or the other, I'd like to start with this. So let's go to the next slide. And we're going to talk about true death taxes, estate taxes, the things that may not be you, but certainly a good number of my clients stay awake at night fretting about. Now, I'm going to start with the federal estate tax here. The federal estate tax is $12 million and some change. That means that each individual gets $12,060,000 of exemption before ever having to pay any amount in federal estate taxes. That rate, if you happen to be over it, is a flat 40%. So it's a very high rate, but the exemption right now is very high. And for married couples, I want you to take this away because I'm about to change the rules on you. For a married couple, each spouse gets their own exemption, and combining those exemptions is very easy without any other exotic, more advanced planning. In effect, all to spouse planning, if you die and everything goes to your surviving spouse, works perfectly fine on the federal side. The bigger concerns on the federal side are, what if they change the law? And just so you know, both the Democrats and Republicans in Congress, I'm not playing favorites here, have pretty much told you in their own way that a big law change is coming, but we're not there yet. And for now, the federal estate tax is not the big priority unless you happen to be worth more than 12.06 million, or if, as a married couple, 24.12. Now, I'd like to talk about this Washington estate tax, because this is something that your friends in other states probably aren't even going to have to think about. The Washington state estate tax is relatively rare. Most states don't have a state estate tax, and Washington's unfortunately hits at a very low amount of only about $2.2 million. As you can see, it's 2,193,000. I really don't like that number, and I would hope that you will not hold it against me, that extra 7,000, if I say 2.2 million from here on out. Now, the key on the Washington side, one, is that it's only 10 to 20%. Sounds a lot less than the 40%, but remember, it's hitting over a much larger amount because you only get that 2 million exemption. And I think perhaps more importantly for married couples in Washington, it is very, very hard to combine your exemptions. In effect, a married couple, two individual people, husband and wife, wife and wife, what have you. You have two individual people, you have two exemptions, but in Washington, you cannot combine them, not easily anyway. And so unless you engage in more tax-conscious planning, it is pretty much a guarantee in this day and age that a married couple who should have about 4.4 million of exemption will only get about 2.2. So Washington estate tax planning for married couples anywhere near about $2 million is a critical area to address. Now, I want to mention one more thing here, and that is that Washington doesn't have a gift tax. The federal government does, and the federal government says that anything you gift during life will be accounted for at death. You'll have less of your exemption at death because of what you gifted during life. Washington doesn't have this, and as a result, gifting, even deathbed gifting, can be a very, very powerful tool to manage a Washington estate tax liability. But of course, it's not that simple. Let's move to the next slide here, because I would be remiss if I pretended like estate taxes, death taxes were the only tax in front of us, and that's not the case, especially in Washington. We're going to talk about income taxes here. And yeah, I know Washington doesn't have an income tax, but that doesn't mean that Washington residents don't engage in income tax planning on a near daily basis, sometimes whether they knew it or not. Although we don't have a although we don't have a state income tax, we do have a federal one, and we have federal capital gains as well. And so knowing that we have pent-up income tax issues, capital gains issues, it's very important in any estate plan, not just taxable estates, not just estates that are worth over a few $1 million, that we've put some thought into income tax planning as well. Even for relatively modest estates, remember, between the period in which you die and your beneficiaries get the assets, the estate, there could be income generated. And that income needs to be managed. We need to figure out in that interim period, who is going to be paying that tax bill? From where is that tax bill going to be paid? And is there anything we can do to eliminate or reduce that tax bill as best as we can? These are all the types of things that come along with planning for broader tax issues than just focusing on estate and gift tax planning. Now, I'm going to mention here one final thing before I move on and let this tax information reel in your heads, and that is that estate planning, tax planning, is very much about looking toward all of the taxes, not just the ones that we're particularly scared of. I'll mention here, that a lot of very, very bad results happen here in this state in Washington when people are too focused, too pigeonholed in the concept of avoiding estate taxes at all possible costs. Sometimes, believe it or not, paying a little bit of estate tax is the best possible result for all other tax scenarios. And so good estate planning and a good estate planner should be able to juggle all of these concerns, not just any one or two. All right, with that in mind, let's move on to the next big picture topic here. And we're going to talk about beginning our estate plan. How do we start this process? Let's move to the next slide here. And I'd like to make sure that we're all on the same page about really what the first planning opportunity is. Traditionally, estate planning has been death planning. And for hundreds, if not thousands of years, that's really all we talked about. We talked about the who's and what's of what happens when we die, where our property is going, who's going to take care of our spouse, our children, our grandchildren, etc. But over the last 50 years or so, we started to see a new planning concern, and that's life planning. That's incapacity planning. And each year there since, especially over the last 10 or 15 years, estate planners like myself are spending more and more time counseling our clients, not on the death side, but on the life planning to make darn sure that you can even get to the point where your will, your trust, your beneficiary designations are able to govern your assets and to have the peace of mind of knowing those assets are still there, that they haven't had to be spent out from under you because of costly incapacity, pitfalls, planning issues that we haven't thought about. Now, I want to make sure we get this element here because this is a little bit unique to Washington, and I don't mean to scare you all, but Washington is a little bit cursed when it comes to our longevity. I'm sure you've seen in 11 different ways, Washington ranks either 1, 2, or 3 as far as top states on pretty much every single life expectancy rubric. We have very low rates of obesity, very high rates of physical activity, very low rates of heart disease. We're a very healthy state. And that comes with a pitfall. Our mental health is bang average. And so for a Washington resident, more so than a resident in almost any other state, we are more likely than most to deal with a position where toward the end of our life, we may be incapacitated for months or even years. And if we don't have a plan to deal with that interim, we're still alive, our death planning hasn't happened, then our entire estate plan may be jeopardized due to what's called a guardianship. If we have to do a guardianship, if you truly have no plan and yet decisions need to be made for you, that involves a very, very expensive, very traumatizing court process that in this day and age, I don't even blink an eye anymore if I see a $10,000 to $50,000 bill for the cost of that guardianship. So good news, as scary as that sounds, all this takes is the smallest amount of prevention. All this takes is for you to put some thought in to what would you like to have happen and who would you like to have serve for you in the event you did unfortunately find yourself in a position of incapacity. And so long as you have pre-planned, the law of Washington, a Washington judge, a Washington court, tends to bend over backward to respect that planning. In Washington and in most states, we use what are called powers of attorney. And there has been for about 15 years now a preference that they be two different documents: a financial power of attorney, usually is called a general power of attorney, and a power of attorney for healthcare, for medical decision making. Between those two documents, between those two buckets, pretty much everything in your life will fall into one of those two. There are some other documents that come along with this, including health directives, living wills, the ability to state your end of life wishes to your doctor today, so that if you become incapacitated, your wishes will still govern. It's also important that whether it be in the power of attorney for healthcare or a standalone authorization, either one works, that you have some authorization that your healthcare agent, your medical agent, can actually get access to your medical information. This is through the HIPAA authorization. And finally, one more item that I'd like to talk about here for incapacity planning. If, for other purposes, you ended up having a revocable living trust rather than a will, I just wanted to mention that revocable living trusts have an extra layer of incapacity planning. In effect, the successor trustee of your trust will govern the assets in the trust before ever talking about a power of attorney or, heaven forbid, a guardianship. Let's move on, and we're going to talk about the death planning side here. So on this point, I'm not going to go through a lot of these concerns. As I'm sure you're reading these lists, you probably have a handful of these yourselves, or you know people who do. But I want to mention here the source of a lot of the planning, the element here that we're going to be working with if you would like to use us as your attorneys or any other attorneys in this state. Most estate planning here centers around a choice between a will and a revocable living trust. There are pros and cons of both. Wills tend to be a little bit more straightforward, but there can be a little bit more work on the back end. Revocable living trusts require a little bit more cognizance, a little bit more work today, but tend to make things easier if done right on the back end. And so I don't have a strong preference, but usually over the course of these conversations, one of these items tends to point itself out as being a little bit better for your particular situation. Now, I'm also going to mention here, beneficiary designations are very, very critical to have properly coordinated with your larger estate plan. And what I mean by properly coordinated here is a little bit simple, but can be very, very convoluted if you think about it. And that is that beneficiary designations happen first in time in most cases. If, for example, you have an account that says pay on death to this individual, person A, but your will says pay to this other individual, person B, there's a conflict. And in most cases, that conflict is resolved in favor of your beneficiary designation. So to put together a core estate plan like a will or a trust will always, always, always necessitate at least a look into how beneficiary designations are set up and maybe even some changes to those beneficiary designations. Now, I'm also going to mention here, second to last item, community property agreements are very powerful tools for married couples. Yes, we're in Washington. Yes, we're a community property state. But what a community property agreement does, that it's unique to Washington, no other state really has this. We can wink and kind of think that Idaho does, even though they have something called that. It's not the same thing. Community property agreement says that everything we own is, in fact, community. This is only for married couples. And at first death, it goes to the surviving spouse. Be simple, outright, without so much as a probate. It's a very, very powerful planning tool if all to spouse is the right answer. And I'm going to mention here again, like I started, because of tax planning, that may not be the right answer. But if it is, in Washington, there's a way to make that happen in a very powerful, very simple planning tool before ever even talking about probating a will, actually administering a will in court. Now, this would not be a business or real property planning seminar unless I mentioned estate planning with business interest usually necessitates a little bit of thought within the business itself, not within the estate plan, right? But within your actual business about what's going to happen after you pass away. Are your partners prepared to buy out your interest? Is there life insurance on the table to make sure that we have liquidity in order to do so? Who is going to take over? Are we talking about transitioning the next generation into your shoes? These are the types of questions that often come alongside estate planning that are very much part and parcel to it, but are nestled within the business documents themselves. And since a good number of this audience has business planning or has, business entities that they're working with, it's important to mention that just doing the estate planning side isn't necessarily going to answer the questions dealing with the business succession elements too. We need to do both of these. Okay, let's move on to the next slide here. And we're going to talk about some basic considerations in estate planning and estate administration. And so I mentioned to you before here, I hinted anyway, that the choice of which vehicle you use on the front end will have impacts on what the work is there left to do after you have passed away. A will, for example, is very, very simple to put in place, but a will is usually something that has to be submitted to court when you die. That's a court process. And so when thinking about the choice of tool, we need to be cognizant about what is the work that we've been leaving here for our chosen successor, right? We often think of this term as the executor, the person doing the labor. In Washington, we call it a personal representative. Same idea, though. And so we need to make sure that that personal representative can do the nuts and bolts of the administration. Are they prepared for a court process? Are they able to, say, pick up your accounts and make sure that the bills are continuing to be paid, that mortgages continuing to be paid, that the funeral and memorial and burial expenses are all either paid or provided for? These are the types of nuts and bolts that we need to be thinking about, not on the back end after things have happened, but on the front end here, so that we can put in, a little bit of prevention so that we can create cascading benefits down the line for your family. Similarly, we need to also think here about making sure that we have contingency planning. It's always, always, always a good idea to have more than just a plan A built into your estate plan. What happens, heaven forbid, if you're the surviving spouse, or if your chosen heir, your child, your beneficiary, your sister doesn't survive you? Where should their share go and how? Likewise, there's usually a lot of questions that follow that. If we're sending it to minor beneficiaries, how long should we hold it for their benefit? And what should that benefit be? Do we want to make sure that they have education expenses paid for, their medical expenses, right? Their cost of living? Or do we want to hold this back, right? Do we want to make this more restrictive? It's very, very important that we've thought about not just the plan A, but all of the contingency planning down the line. Estate planning is first and foremost strategic. And if all we have here in front of us is just our first initial plan, then it's very difficult to earn that peace of mind that we're all entitled to. I want your plan to work, and you should want your plan to work. And the best way to do that is to think a little bit more than just that first answer to the question of who's going to benefit when we pass away. Now, I'm going to leave this slide here with one final consideration. It's not meant to scare you too much, but it is very true. There are all sorts of changes along the lines here, down the line in the future that could happen, that could completely jeopardize your estate plan. Future changes in the law is one of the scariest ones that could happen. But likewise, simple changes in just your net worth or your assets could frustrate an estate plan that you put in place years ago. And likewise, new family members, right? Or, big major family event, birth, marriage, divorce, death, adoption, my beneficiary is getting sued, I'm getting sued. These types of big concerns also have a way of showing up later on down the horizon and frustrating your entire estate plan. So it would be insufficient for me to say that all you have to do is this one stop in time, and that's going to take care of these problems. That's not true. Estate planning needs to be dynamic. As you grow and as factors in your life and the law change, your estate plan needs to be able to accommodate those. Without knowing what those changes are, I can't build them into the document. But what I can do is I can encourage you to update your documents. Every 4 to 6 years or any major life event is always, always, always worthwhile to take some time, half an hour, whatever you need, to come back and talk to your attorney, to check in, to make sure that things are staying up to date. Now, with that in mind, let's go on to the next slide here, because we're going to talk about updating. As I was saying earlier, updating the estate plan, just having a fresh set of eyes on it every now and again, doesn't mean we have to do anything, right? But it does mean that we have to look. That is the single best and easiest way for you all to earn that peace of mind that you all are entitled to when you put together an estate plan. As I mentioned, things change, and so it's important that you all avail yourselves of the opportunity to stay abreast of those changes. Between the assets and family situation on your end and the law on my end, we're going to be able to spot about 98% of things coming down the pipeline, and we're going to be able to head them off before they become an insurmountable problem. Now, I'm going to mention a couple of little trigger points just so that you can put your own eyes on your instrument and see whether this is something that you'd like to come talk to me or any other attorney about. There's been a tremendous amount of changes in tax law over the last decade or so. If your documents are any older than about 10, 12 years, I'm going to suggest that it's worthwhile coming in just to look, right? Just to make sure that none of these other major tax law changes have completely frustrated your plan. I'm also going to tell you that powers of attorney, as much as this drives me nuts, have a way of becoming stale after a certain period of time. Even though the law of Washington is crystal clear on this point that a power of attorney is not affected by the age of the instrument, every financial institution under the sun, without any exception that I'm aware of, has an internal rule where they will push back saying that your document has become too old. After about 10 years is when this starts showing up. And so I'm going to say again that after really about 7 or 8 years, for that reason alone, the passage of time is enough to suggest updating your powers of attorney, your incapacity planning tools, just to make sure they keep working. Same idea, we also had a tremendous law change in 2017. And this has been a very, very sore spot for folks, where your documents written before 2017 no longer work the same way, not your powers of attorney anyway, because of this new law change. You probably weren't told that by the legislature. And so likewise, it's important that we get those documents working the way that they were before that law change so that they stay up to date with your goals and your desires today, but also when you put them in place, right? And of course, this is always the catch-all, but there's been a lot of changes in the common practice in estate planning. This is especially true if you see documents from the late 90s and early 2000s. The way in which planners in almost every state tackled these sorts of problems had a few very, very nasty results that frankly no one could have seen coming 10, 20, 30 years down the pipeline. And so we've changed our practice. What you have put in your document, say 20, 25 years ago, may not be the way in which most estate planners, most practitioners of this law prefer to see that language, not after we have a few decades of seeing what it looks like to actually administer your type of plan. So with that in mind, updates are probably the single easiest, single most important way of making sure that your estate plan meets your goals and that you can sleep easy knowing that you have done what you need to so that your estate plan will meet your goals, your plan, and work for your family. Okay, Imants, would you like to take it away?
Yeah, so that was awesome. Thank you, Grayson. Appreciate it. We do have a few questions, and I'll add a few tidbits. Again, taxable estate planning has not been something I've been focused on, but because we are generally representing a lot of small businesses and family real property holding companies, privately held real property companies, we do get involved with estate administration, typically after someone in the family has passed away. And so I can speak, we're really not trying to create a fear mongering here, but it has happened on many occasions that we are trying to exercise some of the plans that were put in place, and it's clear that they have not been looked at. And so speaking to the point that they do need to be updated, things change. It's a dynamic situation. The other thing that changes quite frequently is the sort of net worth of the estate and the types of assets that are there. So with our clients, they acquire new assets or different assets that would necessitate different tax planning. Those are key issues that can have an economic impact. The final piece before we go to the questions, I will say, because people ask it on occasion, have you had any where you were working on stuff and somebody passes away, and I've certainly heard of that, and it's extremely unfortunate. So if you do start this process, do get it completed to its finality. There are numerous stories out there of folks getting most of the way through their estate planning, but not finally executing it in a conclusive way that would be legally binding. And then whatever was previously in place is what governs, and there's really nothing you can do about it. So on the questions, I think a good question we got was when you say that Idaho has a community property agreement, but is different than WA, can you explain how so? Thank you. I'm gonna let you take that one, Grayson.
Yeah, so Washington community property agreements are meant to be incredibly simple, simplistic estate planning vehicles for a married couple to simply say, everything I own, everything I will own is community, and it all goes to the survivor at first death. It is that powerful, that simple. Now, I'm not an Idaho attorney, so this is my understanding, but it's not legal understanding. Idaho is the only other state that has a community property agreement, but Idaho requires you to identify every single specific piece of item or piece of assets that you want to be governed under that agreement. And if you do not specify that asset, it's not governed. And so practically speaking, it's not used anywhere near the same way or the same frequency as it is in Washington. This tool, mind you, was invented almost 100 years ago and is very unique to Washington, but it has some downsides, and I always keep an eye out to see whether that's the right tool for a marriage.
Another great question. Can you quickly review estate planning factors that would lead you to recommend setting up a revocable living trust?
Yeah, so I actually, believe it or not, was writing a pamphlet today to be giving out to clients. I may actually be able to have this up on our website to download, but for now, I'll give you a quick, easy primer. Wills are a lot less expensive to start, and so for that reason, a lot of people will prefer to go with them. But there are some reasons why people prefer living trusts, and one of those is out-of-state property. If you have property not just in Washington, but say in California or Nevada or my home state of Florida, those exposures in other states suggest sometimes doubling or tripling the complexity of the estate administration, that you would have a probate potentially not just in Washington, but in that other state or states too. And once you start to see maybe doubling or tripling the cost of estate administration, at least being a possibility on the horizon, that often suggests to people to have a more cohesive multi-state plan, and that points to a living trust. If you have property in other states, having them all owned or coordinated around the same entity that will avoid a probate, and so that you don't have to do state-specific administrations, tends to be a whole heck of a lot easier. Right? One other big reason why other people, even if they don't have out-of-state property, will sometimes prefer living trusts is privacy. A will is a publicly filed document. When you pass away, it's part of court, and your tax dollars will go to court, and as a result, that's a public record. Living trusts aren't administered in court. And so because living trusts aren't part of that process, they stay private. Not as a guarantee, right? There's ways trusts can be discovered, but it becomes a whole heck of a lot easier knowing that that's not the default, knowing that they're not as a default going to be submitted to court in an easily discoverable way.
So another great question, what publications, newsletters, magazines, industry publications would you recommend to read on an ongoing basis to stay somewhat up to date on estate planning and real property ownership? I'll take the real property ownership real quickly. Well, actually all of this. Our website has a section called News and Insights, and we try to address most of the big key issues. And I won't say all, but if there's a change in rental laws or a change in limited liability company laws, things you would want to know, or shifts in the landscape, we try to cover them at least briefly and point out other resources. So that's one area. And we will be having additional, as Grayson mentioned, additional information that will be on the website regarding estate planning. And I do think the RAWA, the Residential Housing Association of Washington website, is really critical if you own real property that's residential in nature. And they also have a great lobby group that is good to contribute to if you are in residential housing. Grayson, on estate planning, anything else people should be paying attention to?
Yeah, unfortunately, there's not a really good answer to this question, but I'm going to try because this is not the first time that I've been asked it. I'm going to actually suggest that, in my opinion, by far and away, the best resources for estate planning practices and changes in the field come from attorneys themselves. Just like we will be publishing new information as we learn it and we author it for our audience as well, other firms are going to be doing that too. And so the easiest way to stay abreast of this is to see what the chatter of the industry is like. Now, when it comes to tax planning, there's all sorts of publications that come out, not just through Congress, but also through the Department of Revenue and also through the Washington legislature. And so there have been a lot of proposed changes over the last 2 years, both on the federal level and the state level, that I, for one, am reading. But it would be a little bit presumptive of me to assume that any of this audience is really going to go out there and read proposed tax law from legislatures who may or may not understand what they're actually saying in the first place.
Okay, I just want to clarify that the RAWA is RHAWA, Rental Housing Association of Washington, and we will send out the link. It's www.rhawa.org. Our attorneys regularly speak on at their events, and that's just a great website for advocacy information, great association to be a part of. One last question. Can you give me an example of a situation where a Washington resident would end up paying more in federal taxes by trying to avoid Washington estate taxes? And I'm not sure if that was what that slide said, or if it said
Yeah,
capital gains or
that's a good example. I can run with that one. So this is going to require a little bit of juggling, but I mentioned on that slide, although I did not say it verbally, that when you pass away, every asset that's includable in your taxable estate has its basis reset. The unrealized gain is disappeared. The cost of the estate tax is the estate tax liability, but there's a benefit, and the benefit is that step up in basis. And so it's very, very powerful for income tax planning, for the benefit of your beneficiaries, to have that step up in basis on the horizon. In effect, if you buy a piece of property for $100,000 and you sell it for $1 million, you're paying gain on about 900 of it. But if you die, and then the day after your death, your heirs go and sell that property, they're paying tax only on the difference between the date of death value and the sale value. Next day, probably very, very little. And so this planning opportunity, the idea of willingly choosing to die holding appreciated property so that we can get that income tax step up in basis, is the nuts and bolts of Washington tax planning. Hypothetically, we could have just gifted that property. Let's say you're worth $3 million and it's $1 million of overage, right? You can gift that property. Great. You have saved maybe maybe $100,000 in Washington estate tax. But if there's $1 million of gain, let's say $900,000 of gain in that property, the value of that step up in basis was 15 to 23%. You would be a very, very sad person if you realized that what you've done by avoiding the estate tax is caused your beneficiaries to pay sometimes 2 or 3 times more in income taxes because you were too focused on that estate tax avoidance. So I like avoiding estate tax, do not misunderstand me, but I like avoiding tax more. And if I can get a much, much, much better situation for you, for your estate, and for your beneficiaries, all with the cost of a little bit in estate tax, that's usually the right answer.
Okay, we have a little bit more in-depth question, and so if we can't answer it, Grayson, we'll let you hunt to a meeting potentially with a potential client. At what point would you consider retitling property that is increasing in value beyond federal or Washington state exemption amounts? Or would putting real estate in a trust make more sense? Also, if both owners of real estate pass away, does the retitling process at that point go into the estate name? Well, maybe if you could take a part of that.
Yeah, so this is a difficult question because this retitling process can mean several different things depending on what your choice of vehicle is. If you have a revocable living trust, then in almost all cases, I suggest that you do that titling, right, or retitling to that trust as soon as you can. There's very little benefit to having an unfunded revocable living trusts, like you have nothing. And so that titling process for a trust-based plan should be as soon as possible. Now, when it comes to other assets and it comes to estate administration at first death or second death, that's where I'm going to have to punt a little bit. I'm going to need to know a lot more specifics about net worth, about potential basis, about goals, kids, marriage, etc. So that's exactly the type of thing that we can chew on together, but I don't have any really good one-size-fits-all answers there.
Okay, well, thank you everybody for attending. I guess I also left off the Commercial Brokers Association. It's also a great place for information, and we're members and have seen great value in some of their events over time as well. With regard to estate planning, our contact information is here. I again urge you to reach out to an attorney if you have specific questions. This is again only for informational purposes. We will be sending out a link to the recorded version of this. If you want to pass it on to your friends, colleagues, family, that's great, along with a breakdown. We thank you for your attendance. And thank you, Grayson, again, and we look forward to seeing everybody at our next webinar. Thank you.
Thank you, Imants.